Today, Simon Makonde gets ill. He'll be getting into commercial contracts and the agreements that are going to guarantee his success in terms of traction. We are going to delve into the contracts that are going to fuel your operations, your partnerships, as well as your revenue streams. Why do these commercial agreements matter? The amount of clients that I talk to on a daily basis that are having engagements with people just from the basis of a handshake is insane and baffling and honestly worrisome, because hello, my name is Kega, managing partner of Kega and Company Advocates, as well as the head of legal at Swipe Limited. Welcome to day 4, the day where Solomon Grandi, Simon Makonde, our avatar, in our series of decoding the startup legal life cycle. Today, Simon Makonde gets ill. But in this context, we have flipped the script a bit so that it fits into the rubric that we have been discussing. And so today, as opposed to Simon Makonde falling ill, he'll be getting into commercial contracts and the agreements that are going to guarantee his success in terms of traction. In this respect, in the previous episode, we talked about the importance of forming your first team, both in the context of consultancy as well as in the context of employment. We briefly talked about the contracts that should exist in both instances, as well as the two guardrails that you often need to ensure that you've protected yourself in terms of intellectual property and in terms of confidentiality. Specifically, we canvassed the importance of having an IP assignment agreement for consultants and employees. And in a similar vein, we also talked about the importance of having an NDA, whether mutual or unilateral. Today, we'll be delving into the nuts and bolts of what actually matters, which is making money for a startup. Essentially, I'm going to be very brief because the agreements could be fine in between, and some of them could also be as a result of the particular industry that you're from. And therefore, an agreement that I might canvass might not be relevant for an agricultural company or might not be relevant for a fintech company. The point of this day today is going to paint this with a very wide brush for you to be able to understand some of the things that I feel are important for founders such as yourself to understand. And so today we are going to delve into the contracts that are going to fuel your operations, your partnerships, as well as your revenue streams. As we've constantly mentioned in this podcast, Africa is not united in the way that other continents are. And what that implies on the ground is that we are a fractionalized continent that has over 54 different territories, which would imply different rules governing different things. And so when you're looking at the commercial ability of an African founder to be able to grow and expand, then it becomes very difficult and it becomes very complex, because one requirement is going to differ greatly within one context to the other. And so in this respect, it takes a lot of diligence on the part of you as a founder to determine how to navigate through all these loopholes and still survive as an entrepreneur. In this respect, I am going to cover a few agreements that might be able to paint a better picture for you and guide you with some of the things that you might have been struggling with in the past. Why do these commercial agreements matter? 68% of all startups fail in the first 3 years on account of poorly drafted legal agreements. They result in loss of IP, loss of revenue, unaccounted for funds, or even partners refusing to perform some of their contractual obligations. And one of the biggest challenges is enforcement of some of these terms, or having contracts that have not been properly drafted, and therefore you don't have any reprieve. The amount of clients that I talk to on a daily basis that are having engagements with people just from the basis of a handshake is insane and baffling and honestly worrisome, because some of them have not ended up well. We've had instances of partnerships that have crumbled only for them to be rejuvenated with other partners when other people have been left holding the ball. I'm sure all of us have had numerous examples of other companies or entities that have gone through such a scenario. And so today we'll be trying to look at some of the contracts that you often might need and some of the terms that you might need to pay attention to. The first is a service level agreement. This is a general contract that is going to allow you to have a partnership with different individuals and entities. It's going to cover core terms with your users, your suppliers, your vendors, as well as your partners. And in this respect, you're going to have some certain important variables or terms, such as pricing. So is a price fixed? Is a price variable? Who has the power of amending the price? How do you accommodate for changes that none of you can be able to control? Such things. The other thing that you often are going to have in terms of the SLA are warranties. For me, as a person who's entering into a contract with you, what warranties am I providing to you to guarantee that I can be able to provide the service or product that I have promised? Do I have ownership of the IP? Do I have ownership of the service or product to guarantee I can actually perform? And so when you're looking at such agreements, it's important, it's vital to look at whether this person can actually perform the contract or not, or whether you're dealing with a dubious person. At the same time, it's also important to look at performance matrices. What is the difference between good performance and bad performance, and who can be able to objectively determine whether you've met the KPIs or not? And when there's a failure of KPIs, what are the repercussions and how soon do you have to rectify the mistake? So one of the most important things that I have come to learn as an advocate is having pre-mortem sessions. Pre-mortem sessions is a session that allows you to objectively look at a situation from the end in mind, where you are contemplating the worst things that could potentially happen in the context of that deal and then working backwards. And so assume that I'm getting into a partnership as a fintech with a liquidity provider. And so one of the things that I found valuable is brainstorming with some of the partners that I'm working with or engaging with, where we can objectively look at the situation and try and see all the pitfalls, all the issues that could potentially arise, and then begin solving them from the end in mind. That is referred to as the inversion process, where you essentially try to think about all the bad things that could happen, and then you try to rectify all the bad things that could happen. And so that's going to be a very important yardstick, especially in the context of today, where you should try as much as possible to look at all the wrong things that can happen and then work backwards. As I said, some of this is not going to apply to you on account of the domain that you operate in. And therefore, I will not be very, very specific. Other seasons of this series are going to explore some of the nuances of specific agreements, maybe specifically targeting a particular industry. And so we can be able to go into more detail then. But for today, the main takeaway is the pre-mortem sessions and why they're important to you and in any engagement that you'll be having. We've talked about the SLA, and that's normally the general contract that you're going to have. But depending on the nature of your agreement, you could also have a partnership agreement that could be of a unique nature. It could be equal in terms of the split. It could be unequal or disproportionate in terms of the split. It could result in a merger. It could result in both of you forming a joint venture to be able to achieve the particular objective that you've both decided upon. But then again, it also determines, it is also dependent on the exact thing that you're trying to pursue or do. We've talked about SLAs. Now let's delve into sales contracts or customer contracts. So the reason why this is important is that it allows us to be able to have B2B and B2C sales. B2B meaning business to business, and B2C meaning business to customer, where on one hand it's retail and on the other side it's mostly institutional. And so this is mostly going to include pricing, warranties, refunds, issues of data usage, issues of terms and conditions, things that are going to allow your customer to have the ability of using your product or service well. At the same time, it's also important to note that in certain jurisdictions, there are some very high penalties that are going to arise on account of your non-compliance. So what I mean by this is that, for example, in the US, when you have emissions, then the emissions are going to be charged per unit of vehicle or thing that you've been able to manufacture. And so assuming that you have a plant that is producing 1 million cars and you need to pay a fine on each of those units, then it starts becoming a very, very huge problem in terms of how to deal with that. And so even as you're dealing with sales contracts and partnership contracts, sometimes there are some things that are going to be grounded in law and that you also need to be aware of. And so there are things that you can be able to regulate yourselves and as parties in terms of the contractual obligations that you actually have control over. But at the same time, there are some things that are also going to be statutory or legal that you do not have control over. They are regulatory obligations. And so in the same way that I mentioned that pre-mortem sessions are important, is the same way that understanding that there's a higher hierarchy to the commercial contracts that you have, which are the legal and regulatory obligations that exist over and above the contractual ones that you want to get into. And so in that respect, even as you're looking at different sales contracts, it's important to also look at some of the consumer protection obligations that you have, some of the data protection obligations that you have, and some of the legal obligations that you might have, for example, in relation to children, if you're operating a site that would have such limitations. And so looking at it from that lens is also important to avoid issues of non-compliance or penalties or even imprisonment. And so, as I said, I'm going to be using a very wide brush in terms of discussing some of these things. The other document that is important to discuss is in the context of IP. So this could be an IP assignment agreement. This could happen even in the context of one entity to another. But you could also have licensing and distribution agreements where you are using someone else's license or you're using someone else's patent to be able to do something specific. And so this would potentially mean that there are royalties that are being exchanged, that there's some tax obligations that would need to be done, and that there's a level of reliance on some of the things that both of you are saying that you're going to do. And so when you're looking at license agreements specifically and in the context of some of these assignable rights in the context of IP, then you'll find that often the term is going to be between 1 to 3 years with an option of renewal. And that there's also going to be some costs in relation to management and costs of maintaining the IP. So whether that's maintaining a particular trademark, patent, or industrial design, or whether that's maybe maintaining the property as you might need to do, it's important to ensure that you are aware of all the hidden costs that might potentially exist. At the same time, for me, as a person who might be obtaining some IP from an individual, what rights do I have? Can I reuse it? Can I adapt it? Can I resell it? So defining some of these obligations is going to be very important. And some of them are also going to be couched in the context of the territory that you might be operating in. And so what I mean by that is that some of the agreements that you have might be limited to Kenya, for example, Nigeria, the region could be limited to Africa, could be limited, depends. And so my point is most of these agreements are mostly going to revolve around the particular dynamics of your particular business. At the same time, NDAs are very important because sometimes deals do not materialize. And the worst thing that you'd want to have is a person holding your very critical proprietary information and confidential information, and then they proceed to use that information to create a clone of your product or service. We've seen this happen multiple times, and I don't want to mention names, but we're all familiar with what has been transpiring, both locally and abroad, where we have founders going to present ideas to VCs or to various institutions, and then they find that they're actually presenting to other developers, and then their product gets cloned. A very perfect example of this is in Silicon Valley. Not exactly sure of the exact episode. I'm going to drop it down in the comments below. Also, if you've watched Silicon Valley, I had intended to use that as a learning tool because it's very, very practical. I'm not entirely sure whether I should add clips of the same to the episodes. And so I'd really want your comment, especially as we begin designing the season 2 of this series, so that I understand whether you'd want us to just maintain it as a purely conversational podcast, or whether you'd want us to be adding in aspects of AI, maybe memes, or things that would be essential as learning tools for us to maybe have a more collaborative session. Your feedback would be important. And so, as I mentioned, an NDA is going to be very important to protect yourself. And even when you're having engagements that might not materialize, you might need to have provisions that might prevent them from using the information that you've given them to either resell or reclone your product. And depending on what you're offering, the dynamics could be different. Again, this is a day that is very, very interesting because you need the advice and the services of your legal counsel to be able to tell you what agreement would be relevant where, in what circumstances, the legal obligations that might supersede your contract, as well as the things that you can do to protect yourself both before, during, and after the deal. And so the point of all this, as we've been discussing, is acting on or from an abundance of caution, where we're trying to protect the thing that matters the most to us, which is the startup, the child, the idea, the product, everything that we find valuable as founders, especially in the context of startups. And so in that respect, I hope I've been able to demystify some of the commercial agreements that you might need to get into in future, how they're going to apply to you, as well as some of the things that you need to do to protect yourself. As a parting shot, we mentioned that there are very important two main takeaways from this particular episode. One is the pre-mortem sessions to ensure that all the things that could potentially go wrong are considered. That you're using the inversion process at a time where tensions are not high, because when you're starting your agreement, both of you really want to pursue the arrangement. And so when you take that as an opportunity to look at all the situations that could go wrong and essentially try and resolve those issues from the onset, then it becomes a very easy process for you as you proceed. And then finally, we mentioned that deals are going to materialize and some of them are not. And so protect yourself, one, in terms of the information that you're going to give. Be very stingy with your information, especially when you have not been able to sign a particular document. That might not be very practical advice for very early stage startups, because the level of asymmetry that you have with institutional players is going to prevent you from maybe protecting yourself in that way. But when you begin to see that the rubber is meeting the road in terms of the deal, kindly get legal counsel to advise you so that you don't end up getting screwed. And from what we've seen, over 70% of startups fail in the first 3 years just because of legal pitfalls. And so take care of the thing that matters the most, which is the business and sales, because sales cures all, and today's purpose was to increase the commercial viability of your business, the traction, and the scalability. And so thank you so much for having joined us, founders, doers. It is always a pleasure to demystify some of this knowledge that we've been able to acquire over the years. Subscribe, like this, share this with your founder circle. And if you have any question, kindly drop it on the comments. We'll try our level best to answer any concern that you might have.